there was one motion in limine that he wrote while he was pro se.
Oh yeah, absolutely. People think, well, if he's working for free, he doesn't care. He just wants to deal it and get it done.
Historically, when people use the term star chamber, that was in British rule, where literally the king would just give you a lawyer to facilitate your prosecution, even though they were supposed to be for your defense.
What is there any group, and I'm looking for an answer here, that goes towards pro per more than another?
Sovereign citizens, bing!
Bang!
Sovereign
tell
citizens.
me about that. Tell me how that works.
Oh.
Okay.
I'm your host, Scott Coffey, and we're here on Our Nevada Judges to talk about self-representation and the right to stand by counsel. It's a subject that's near and dear to my heart, and I think it's appropriate to be discussing it on the eve of the 60th anniversary of probably the most successful case of self-representation that I'm aware of, Gideon versus Wainwright, that established the right to appointed counsel in cases where liberty is at stake. Abraham Lincoln, of course, famously said that anybody that represents himself has a fool for a client. Hopefully by the time we're done with our panel, we will be able to answer whether that's still true and maybe make some of our viewers aware of the pitfalls and prats involved in self-representation and the right to represent yourself and the right to stand by counsel. To my right, I have a distinguished panel of local attorneys, and I am pleased to welcome all of them to the show today. We have Theresa Maines,
Ben Bateman.
Ben Bateman, and my dear friend Fikisha Miller, and I'm going to let each of them tell you a bit about themselves. Go ahead, Theresa.
My name is Theresa Maines, and I have been practicing in Las Vegas for close to 6-7 years. And I'm also a forensic accountant. Part of my experience with people that want to represent themselves pro se is on the forensic side, appointed by the NJA, and on the legal side. I'm with Whitehead and Burnett, and we are business attorneys, and I work with fraud on defending and the prosecution side on civil level.
Yes, my name is Ben Bateman. I've been licensed here since 2005, and currently I'm a solo practitioner, and I've been about 8 years now. And I am on the panel, it was at the Office of Appointed Counsel's panel. I do have a track now, but I have some experience being appointed to stand by counsel because of that. And so I've been practicing mainly criminal since about 2007.
Fikisha, you've done almost everything.
I have, but just really briefly for our viewers, I'm Fikisha Miller. I've been practicing law for 20 years, licensed in the state of Tennessee as well as Nevada. I've been here in Nevada licensed since 2014. At the Public Defender's Office for 6 years. I've done criminal practice most of my life, except for part of the time when I was in private practice where I did mainly civil. The last year during the pandemic, I was the chief negotiator for Clark County School District and got the schools back open and running. And then now I'm in private practice as senior trial attorney at Nevada Defense Group. So.
Very good. And by way of background, I'm with the Clark County Public Defender's Office. I've been there since 1995. Hard to believe. I have the gray hair to show it. I do primarily capital work, and have done capital work for the last 20 years. But even with that, we get self-representation on occasion. So let's start by talking about self-representation. What is it? Well, let's just start with that question. What's self-representation? How does it work?
Well, someone wants to represent themselves. I think generally when I see it, there's always that sentiment that no one can represent me or defend me as well as I can. And just either because they know all the facts they went through, the facts of the experience of the case, or they've studied so much that they know. There's also another sentiment that they know more than the attorney does. It seems to be a common theme in people representing themselves.
And no more than the attorney does about the case, but usually not about the law, I would imagine.
Depends on the individual, but usually, yeah, they want an attorney, usually a standby counsel, maybe someone to help them procedurally, but yeah, usually the sentiment is they know more, and so they're best positioned to defend themselves.
How do the courts receptive to this idea of standby counsel?
Well, if you're talking about historically, yes, that's where the whole framework comes from in our constitutional amendment and why you have the right to represent yourself. So historically, when people use the term Star Chamber, that was in British rule, where literally the king would just give you a lawyer to facilitate your prosecution, even though they were supposed to be for your defense. And I think it's really amazing that, 300, 400 years later, we are now seeing our public feel the same way, that they cannot be defended by the system or court-appointed attorneys, that they can do better all by themselves, or maybe with the help of somebody sitting at their elbow.
And I suppose there's a natural tendency to be concerned about somebody, you say appointed counsel, somebody you don't pay for, right? If you're not paying the bill, you worry that they're working for the system, maybe not you. Have you encountered that as a
Certainly.
appointed counsel?
Oh yeah, absolutely. People think, well, if he's working for free, he doesn't care. He just wants to deal it and get it done because he's not. And a lot of times, it's something I, tell them. Usually to gain credibility is, hey, going to trial is in my interest because I get paid. I get paid for going to trial. I get paid hourly, and a lot of times they're surprised they don't know that. And so I'm like, me telling you to take a deal that trial is not in your best interest is really for you, because for me it would be better. I would make much more money on this case if we went to trial. But my job and my ethical duty is to represent your interests, not mine.
Is a public defender in the same spot, though they're salaried, right?
Yes. So I'm different than a public defender in the sense that I'm usually these cases, I'm paid hourly and not just by.
Well, and it is hourly. Like with federal, there's the NJA, and it's a lower amount, but it's still hourly. I mean, my experience with I've never been standby counsel. I covered for a very, very prestigious, in my opinion, very well reputable attorney, David Fisher, after a motion to proceed pro se is filed, and this person wanted to defend themselves, and it wasn't anything against the appointed attorney. It was more of like an ego, in my opinion. This person, you already hated, at least have a shield. The procedural rules were probably the most challenging for that person wanting to proceed, for himself.
Well, and that's a good question, I think. Those procedural rules, do they apply to pro se? The same
Yes,
as
yes.
attorneys?
And I think that this federal judge was very clear. This is your right. She did the canvassing of from the hearing to determine whether he's of sound mind. Does he know that he goes to trial, the maximum penalty will be 300 months?
And we talked about canvas. What we're talking about is a series of questions that the judge would be asking.
Beretta canvas, that's right.
Beretta canvas.
Beretta canvas,
That's the case.
That establishes the right to represent yourself in any case, essentially, right? Including capital cases.
Our Constitution says you have the right to represent yourself. Beretta is the case where, though the court did not want the person to represent themselves, that sort of entrenched it under our Supreme Court. But yes, actually, our Constitution says we can represent.
Why would the court not want somebody to represent themselves?
For multiple reasons. I think despite what clients think or what the public thinks, generally, if you have a competent lawyer, the trial is going to proceed more efficiently, number one. Number two, you don't have to slow down and explain things to another attorney like you would a pro se litigant, because as the other panelists mentioned, the record is everything. So if you have, and I mean, they're pro se litigants, I mean, they're coming out more and more. I've seen a real big movement toward this in the last 10 years. And so I have seen people that you would never expect that would want to represent themselves. I believe there's one that's in trial, just wrapped up here in Clark County. I believe the pro se litigant was mute and could not speak. And so all of the questions that they had to ask.
They're in jury selection right now. It's taken 7 days so far.
Yeah. So
It
that
take usually
2. Well, in a murder case, 3.
Was he muted, or that's a physical, he could not speak?
He cannot speak, is my understanding.
Okay.
So, yeah. So, but I mean, you have the right to do that. But for court efficiency, if you had a lawyer to speak for you, and excuse the pun, but that would be a different instance. The other thing is that it protects the procedural rules. Lawyers understand the process. You have a less likelihood of reversal. And I think there is the idea of a shield that when you have especially heinous charges, that in order to have a meaningful defense, you need to have someone else speak for you. That's why, if you don't testify, it can't be held against you. You had someone to speak for you, even though it's not evidence, but to ask the questions you could have asked.
We give juries instructions that say you're not supposed to prejudge things, you're not supposed to make a decision until the facts have been presented to you, till the witnesses are done. Do you think they actually follow through with that, though, with a pro se litigant? For example, in your situation where you have somebody accused of a sexual offense.
Heinous was like the key word. In that one, and I think that's like an extreme case, but it gives every single example. There was one motion in limine that he wrote while he was pro se. So, fast forward when he's in trial, and there was a lot of stuff that it was excluded from, like past offenses and everything. So if he's in trial, he can't discern what is excluded, what is not. And whose fault is that? That's like,
And Bennett mentioned credibility. With a client, there's also credibility in front of a jury, and I have to imagine it is difficult for somebody representing themselves to stand up and say, trust me, I didn't do anything.
Right. And also just I think your question of, why would the courts prefer an attorney representative? Because I think if someone is pro se, I think there's the temptation, maybe they don't care. They don't have a bar license to worry about.
Right.
It's their life on the line there, whatever, their freedom, their future. And so there's that kind of, I think, the feeling maybe like a wild card, like you don't know what's going to happen. If things are going poorly, is this guy going to shout out? Is he going to do something crazy? I don't know, But I think there's that concern that, one, not being bound by, bar exam or losing your profession, your livelihood. No attorney is going to, you can zealously advocate, but only, I'm only willing to risk so far for that. I'm not going to put my license in jeopardy.
When I've watched it in the past, too, I've seen clients who are adamant about representing themselves, and then they get in the courtroom and they get stage fright.
Yeah.
It's like being on a high dive and having to jump off, and they cower up and maybe don't ask the questions that need to be asked or pay attention to, right? As attorneys, our best skill is listening, and it's hard when your life's on the line, I would imagine, to listen to what's going on in the courtroom.
Especially objectively, right? Instead of arguing with the facts that are presented. As a lawyer, that's one of the benefits of neutrality, is that you can step back, objectively look at facts, look at evidence, how it's going to play. You have an audience, it's your jury. And so when you get to trial, I think it's really obvious. I think the impact and influence on the judge and that relationship, all that pre-trial litigation that goes on, I think that if you have a judge that can maintain their composure, especially with a very emotional or outspoken citizen accused, then you're going to be on a good path. But I've seen judges that just can't hold it together for a good cause. That the clients have gone off ballistic, they've gotten physical, they've gotten loud, they've gotten insulting to both the district attorney and the judge, and you still have 45 cases sitting. So pro pers take longer. They take substantially longer because you have to build that record to make sure that everything is knowingly and intelligently waived, that everybody's on the same page. But the other thing that I love that courts, and you can see it in the judge, you can see it from the bench, you can see that they're looking at the district attorney saying, hey, you still have all your discovery obligations, and you have all of these file review obligations and things that you have to turn over. And the district attorneys are very used to dealing with other attorneys. They don't have to redact things. They don't have to, have criminal defendants into their office to do file reviews. So.
Do the district attorneys have an obligation to treat pro pers better if they miss something, if they miss some objection or something, or can they take advantage of a pro per?
I would like to think that they would be, be a little more fair or a little more patient with the person. It's not, I can't stand dealing with prosecutors, and you know them. Probably don't need to name names, but there's some that care more about winning maybe than being fair, and there's others that I believe are that are fair and reasonable, and so I always appreciate that when they're a little bit more fair. If someone doesn't really understand that they wouldn't take advantage of it, I'm not saying that they need to roll over. Obviously, they've got their job to do too, and they can certainly do it. But I'd like to think they would be take that into consideration and be fair. But
And I see a giggle here.
Oh, I'm sorry. I will always giggle.
I'm a dreamer. You can't take
You're
that
a
away
dreamer.
from me.
You are a dreamer. But no, and to your point, and I have said this, I think I learned it in law school, you can't teach somebody to be ethical. Okay.
Yeah.
So to your point that some prosecutors want to win at all costs, they've shown their ethical card long before a pro per ever showed up.
Right.
And those that are fair and would always be fair and respectful and courteous, I think it's more just a pain because they understand that they have to slow down. They have to do all the things to make sure that the pro per understands what's going on, because number one, they don't want reversal, right? They don't want, and they believe that you have that right. I mean, even though it's a pain, even though it slows things down, and if everybody went pro per, we would not know, the system would collapse, right? I mean, I honestly believe that you would have to triple and quadruple courts just because of the time, and then imagine all the appeals, and imagine all, it would really, there's things that the system doesn't want, and so I think for the district attorneys, I think I've seen some that are very fair, remarkably fair. So far that, they're like, I don't want to convey this offer without having a defense attorney present, even though you have a right to, and they do it every day. They deal cases with unrepresented people all the time, yeah.
But they go into courtroom wanting to win the case, I would imagine.
I'm sure.
And I think in my own practice, with having done this for a long time, we don't send new attorneys in to do capital cases. You have to have some experience under your belt because new attorneys tend to be taken advantage of. And I think about how much worse that would be without a law degree and without someone to help shepherd you through the situation and help you make a record. We talked about making a record beforehand. How do pro pers do with that?
It depends. I actually represented a man from Chicago who went pro per jury trial and beat his case.
Wow.
So as rare as that is, I actually represented a gentleman who had gone from Chicago, had a very serious attempted murder case. I was at the public defender's office. And the very first thing he said was, you don't need a lawyer.
Right.
I don't need a lawyer. I don't need you. And I stopped. I said, hold on a second. Do you know who I am? And he stopped and looked at me. He said, no. And I said, but I don't know who you are. So, always turn the card. And I let him talk about how he was in Chicago, had lived his whole life there, had come to Vegas for a family issue, got into trouble here, but that he had done this in Chicago. I verified it, he had. And I said, well, why don't you think you need a lawyer? He's like, well, I've been in and out of the system so many times. I knew exactly what and he had, but I knew exactly what I needed to do. And I've beat it before. I've done this before. I don't need it. And I just explained to him the excellent work. I don't dismiss this.
Right.
I've confirmed this. And in fact, I think that's amazing. Like, it rarely happens. But how many times have you done it in Nevada? And he was like, oh, well, I was like, well, the procedure's different here.
Yeah.
And you don't know what's going on here. I said, how about you just try my services? And if you don't like it at any time, you have, and I've told clients constantly, I will send them Ferretta if they want to represent themselves. It is your right. And so it's not me to say that I know better. You want to deal with the consequences? Everybody's an adult and a competent, and so there you go, and let the ship sail where they may. But once he saw what I could do, he was very pleased. He accepted my services, and we resolved the case to excellent resolution.
So procedurally, how would that work? I'm accused of a crime, and I come into a courtroom, and somebody's appointed, a public defender or appointed counsel. What's the difference between the two, by the way?
All publicly provided attorneys are appointed counsel. Public defenders handle the general public. Track attorneys will handle the conflicts from the public defender's office because there's so many clients, there's so many people, so many defendants, and you can't represent a defendant where the victim is a previous client of yours, right? But because there's so many lawyers, you multiply that. You have track lawyers.
Or multiple defendants.
Multiple co-defendants, that sort of issue. And then you also have the special public defender's office here for those felonies, and above, life tails, those sort of cases that work as a systematic conflict for the public defender's office.
Here in Clark County, we've got 110, give or take, public defenders and another 15 or 20 special public defenders, Office of Appointed Counsel, and track attorneys, probably double that number, close to.
Yeah, about that.
Close.
Yeah.
But close. How does that work with the public defender's office? We're talking about conflicts. I've represented somebody on a drug case and they're a witness in a case you're going to pick up on an attempt murder. Does that mean you can't take that attempt murder if you're in the same office as me?
Yes, that's exactly it. So our ethical obligations to a client exist after our relationship with that client exists. As a lawyer, I cannot defend somebody where it would require me to cross-examine a prior client because I know everything about that client, right? I've got all the dirt. I know their family. I know their truth, right?
Know where
I
the
know their
bodies are
drug
buried.
issues.
Where the bodies are buried.
I know where the bodies are buried. So, I mean, and imagine what kind of relationship anybody could ever develop with a lawyer when they knew that you could turn around and use it against you. So, I mean, the system works. I mean, the point of the system works as long as everybody respects it.
So if I'm a defendant and I come into courtroom and I don't want my public defender, should I ask for an appointed attorney? Am I going to do better with an appointed attorney?
You don't get the choice. You don't get the choice.
It's not that easy.
It's not that easy. No,
Not
it's not.
quite.
Talk about it a little bit. How's that work?
Well, they have to qualify for the public defender. I'm not exactly sure what the number is, whatever that would qualify someone for the public defender, but there has to be a need. If someone earns a,
They own a house and a plane, they're not going to get the
They're
service.
in custody. Oh yeah, when I was at the PD's office, I've walked out and had a client get in a Maserati. I was not happy.
Yeah.
Right? I was not happy, but I have had that happen.
If I go out and I hire Mr. Bateman and I don't like what he's doing for me, and I doubt that would be the case, but if it were the case, I go to Ms. Maines, walk down the street and hire a different attorney, correct, or Ms. Miller.
Yep.
Does it work the same way if counsel's appointed?
No.
No.
How do I go about getting rid of my appointed counsel if I don't care for them?
Some of you get in the mail a handwritten pleading saying, motion to dismiss counsel because they haven't come and seen me in 2 days or whatever it is. They haven't given me my discovery. They haven't done this. They're not doing anything for me.
They're not answering my collect calls
Yes,
at 4
and
o'clock in the morning.
So that is usually the one motion that will get through, not treated as a fugitive document and gets through and gets put before the judge. A lot of times it's just that they want to hear from you. It's a balance. Their case is their only case. And I mean, I do tell this to my clients all the time, like, I budget my own time, and I understand your case is, is important to you, it's important to me, but so is everyone else's case, and your case is 3 months out, I've got one that's set for trial next week, it's either gonna, so, excuse me if I haven't been here, but I'm not neglecting you. It's all a balance. It's sometimes it's difficult, but so sometimes you can smooth things over. If not, or sometimes you say, look, I don't have any opposition to this person's motion, but they have to file a motion. There has to be cause, obviously, and and sometimes I'll do it. I've filed on rare occasion, but I've done it where they just refuse to cooperate with me. If they've just decided that I am not helping them, or I'm not competent, or I'm just not, it's just kind of fold their arms, shake their head, and I'm not answering your questions. I'm not going to help you. So at that point,
A breakdown in the relationship.
yeah.
Do you have to air your dirty laundry in front of the court, or how does that work?
You got to keep it classy. I mean, I never like that look when I see attorneys do that. You're still your client, and I don't understand the point of that, but sometimes I think personalities, both sides, get in the way of good behavior, good public behavior, but.
And here in Nevada, we've got something called a Young hearing, right?
Yes.
Mm-hmm.
And that goes to a breakdown in the relationship between
A material breakdown of the relationship, yes.
the attorney and the client. And a Young hearing would take place outside the presence of the district attorney, so we can avoid having to
Air the dirty laundry.
air the dirty laundry. Of course, you still have the dispute in front of the judge, I suppose, and that may not be a good look at that point either.
And sometimes, usually I think most judges know when you sort of put because obviously you still have the obligation to protect privileged information
Exactly.
and things like that. So usually I think judges know when you put the language, communication has broken down, or there's certain, I don't know, I call them dog whistles, but certain phrases that you put in there that the judge understands, okay, there's something that obviously he can't divulge, and so, and it's usually both parties at that point, if they'll ask, if they agree, then it's usually granted the motion to withdraw.
Yeah, and I think that now I have my civil hat on because I don't do criminal law as a, unless I'm the forensic accountant. So I've just covered really mostly for David Fisher. But on the civil, there's I think there's 4 criteria, but they're given from the professional rules of conduct.
And that brings up an interesting point. If you're hired as an attorney and you don't get paid, that's a basis to withdraw, I suppose.
I think it also depends upon how far you are into the trial. That mixed with somebody wanting to now go pro se so close to the trial, that may be grounds for the judge to say, no, it's too now into the trial or close to the trial.
Well, and I think that's a great point. I've got a capital case right now where I've got a fabulous relationship with a defendant who's going to represent himself at a capital trial despite my best advice. And those things happen, and in that situation I am going to be, I think, appointed standby counsel. That's what the court has said. And that's a little different than what we've been talking about with pro se. Pro se is essentially just coming in and you're by yourself on your own. But there's kind of a in-between situation with standby counsel. Let's talk about that a little bit. How does that work?
Well, depending on your jurisdiction and which judge. So I think that there's been a pretty clear confusion between the terms standby counsel and elbow counsel. And I think traditionally those have been considered differently. Of course, whenever a judge appoints an attorney to a client, there has to be a conversation. There needs to be a conversation on the record if it's anything other than the traditional attorney-client relationship. Because I think not only from the case law, but just in practice, as an attorney, you need to know what your parameters are. And standby counsel, I think for all of history, has been considered counsel that stands by the ready to jump in and take over a case whenever the judge determines that it's appropriate. Whereas elbow counsel...
How comfortable are you with that?
Well, if I was standby counsel and I was given the time, preparation, and all the due, all the bells and whistles that come along with being counsel of record, meaning I've just had done the discovery, I've interviewed the witnesses, I've done everything I would to prep for that trial. I don't have a problem with being standby counsel because I think, standbys truly stand by because at the point that the client freaks out or I can just pop in and go. Elbow counsel, I think, is a very murky place.
And you're talking about hybrid counsel.
So what these elbow counsels, and so to me, the way I've always contemplated elbow counsel is that I am sitting at your elbow, whispering in your ear if you ask it, or if you have the question as the client, and you're my client now, if you have a question about the procedure, or if I see
I would like you to represent me then. You do better than I will, please.
So like a question about the procedure or an objection should be made, I'm at your elbow. I'm advising you can take advice or not. But ultimately, with any of these, before I'm tagged in as standby counsel, every single decision is the client's decision. And when you're the attorney, every single decision is not the client's decision. Very few decisions are actually the client's decision. But when the client is leading the representation, I think that it behooves both the clients, the attorneys, and the judge themselves to actually very clearly define what the client is getting, what the client is not getting, the obligations of counsel, what is not the obligations of counsel. Not only that, but whether or not this is a standby where you need to be ready to go because I'm entitled to a continuance in order for me to be prepared because I have a license, or versus elbow counsel, I will never go. I will just be there advising you on the law on the fly.
But you're talking about the cleanest situation, right? Where we've got standby counsel and before things go wrong, they say, I want my standby counsel, and I've decided I don't want to do this. What happens when they're 3 days in trial and they've got up and perjured themselves or done whatever it might be, and then they go, oh, went bad. Can I have somebody take over? Is that more difficult?
It is more difficult because the attorney, I think, comes in and says mistrial, right? Like if I'm the attorney of record, I'm protecting the procedural process, which I don't think a judge is going to want. But I don't know. What do you think?
Boy, that would be a nightmare scenario. And I'll be honest, I had a different understanding of I thought elbow counsel and standby counsel really just two words for the same thing. I know when the first time I was appointed, it was Drew Christensen told me, hey, this person's been, had the Feretta canvas, they're their own attorney, you don't give them legal advice. What you're gonna do is help them with things procedurally, help them, if they need help with, formatting or the subpoenas, how to do those things, but all those decisions are theirs and not yours. And so, that being said, I wouldn't want to, especially if I had a major disagreement with the trial strategy of the pro se, I wouldn't want to jump in, 3 days after trial on a trial strategy that's not mine that I disagree with. Yeah, that would, like I said.
How about a client with mental illness as an example? And that's kind of common in pro pers, I hate to say, but a client with mental illness who's decided not to consult any mental health experts, and you get 3 days into trial, and that would have been your strategy if you were the attorney.
Right.
Problematic, right?
Can we continue this 21 days so I can give notice of my expert witness?
Well, it's so counterintuitive because if you think about it, you have to go back to what you said in the beginning of this. This is their right. Okay, this isn't like another choice of counsel. This is your right. So with your example, with that judge saying no legal advice, okay, that's it. That I think protects the record with every single decision made, whether you perjure yourself or not. You don't want to get any kind of expert. That's your right. It's not your choice. It's your right. And that, I think, if you put it in that your constitutional right to screw everything up for yourself, so then if they decide to get an attorney and you come on and say mistrial, of course I've never experienced that, but I don't think the judge would, I don't even think an appellate court would look at when an attorney messes up in fact, I don't think that would apply.
Oh, it doesn't.
You can't protect yourself, represent yourself, and then say, "Sorry, ineffective against assistance of counsel." You can't do that. It's like
so you've given that up.
Well, but I think that it behooves everybody to make sure it's really clear on the record.
Yeah.
Because I have seen attorneys say, "Okay, I'll be elbow counsel," and then the person says, "Tag, I'm out," and you're like, "Well, I'm just your elbow counsel. I'm not prepared to step in."
Right.
So I think that especially Nevada really doesn't have statutes or rules about how this works, and just across the country, there's so much varied law about it. But it is if you're talking about a jury trial at that point, it is the district court's responsibility to make sure that all the litigants understand what you're waiving, what you're giving up. That's part of the Feretta canvas. So I don't think the person representing themselves could say, okay, now I want a mistrial. I messed all this up. But I think as an attorney, procedurally, you do the work. Okay, you're going to be denied, granted. But then you deal with the cards that are dealt.
No, you know what? On The Good Wife, she did represent this wacky client, and he represented himself. And I don't remember. I just remember it was the impatience and how he wanted to represent himself, and he was just like this, just really bad defendant. And she was standby counsel. I forget the story, but I just remember the humor in that, of the impatience. So you just want to clobber the person.
And not to tag anybody as being a good or bad defendant. Not my.
Not my place.
But being a public defender for 30 years, I don't pick and choose my clients.
This was on TV, so.
What is there any group, and I'm looking for an answer here, that goes towards pro per more than another?
Sovereign citizens, bing!
Bang!
Sovereign citizens.
Tell me about that. Tell me how that works.
Oh,
Okay. Well, what do you know about maritime law and admiralty?
I actually used to have a sailboat, so I know a little bit about that. But no. That's so basically the sovereign citizen movement has grown, I think, out of Wikipedia, but it is this belief that you are because we're not ruled by a monarchy, that we can basically throw out all U.S. law. For a court to be able to rule over you, they have to have jurisdiction, right, over the subject matter, the place, and the person, right? So basically, once they figured out, that's just Law 101, they object to the jurisdiction over their person. So there's a multitude of ways I've seen this argued, some of it very cleverly, whether it's through our prior treaties, our maritime law. There's all these other different theories that the United States government or Clark County government or wherever you're residing does not have physical control over the person that you are. And so because you are a sovereign, you are your own king of the citizen of the land that you reside in, your body, that no one else has any authority over you. So because the court does not have jurisdiction over your sovereignty, over this royal we that we are, that they can, everything that the court is doing is improper.
Are they ever successful?
Yes.
Well, yeah, I know there's one video. The guy just said, yes, he did not consent. I've seen the video that did not consent because basically, it's sort of an extension of what, my political science degree finally came into play, being worth something. But the concept of natural rights, obviously, in the Declaration of Independence, that those rights are of our life, our liberty. They didn't come from government. We are born with them, and so then, since they didn't consent or opt into this sort of social contract or this government, that they're exempt because of that. And there was a ticket in municipal court, and the city attorney was dealing with this guy. He's asked me, "Could you talk to this guy just as a favor to me?" So she's like, "Yeah, he's just." So he's telling me, yes, he was a vessel in the course of commerce, his car, and so maritime law was applicable. And I'm like, well, you're also driving a car on the streets of the incorporated city limits of Las Vegas. So yes, this judge does have jurisdiction over him because he's saying that, some sort of admiralty law and he's exempt from doing it. And it's just bizarre. I don't know how anyone thinks living here in society that they're exempt from.
And to be honest, I've seen it, and oftentimes it derails the process in a way where it goes completely away from the facts or the allegations, and the people end up in prison, and some of the times on the bad end of things from the judge also, who tends to be frustrated with shenanigans.
It's considered shenanigans, but I have seen it very, very successful. I don't know if I even want to put this out there in the public, but it does work. It generally works on low weight, low monetary value cases like traffic tickets, right? Because no one has the time for that. It is turn and burn, and I have 400 traffic tickets that I've got to get through in this docket, and even a city attorney is going to be like, okay, I just can't with this guy. And they will dismiss the cases sometimes, okay? That if it's not worth it, they don't have the time, bad day, if all the factors align, sometimes it is successful. But what it is most likely successful for is you understand that this is wrong. And I think prosecutors are pretty good with ferreting the people who have found it online that are not sworn into that strategy, saying, hey, well, I'm sovereign citizen. And if you go through about 5 minutes worth of questions, you can figure out whether or not they really believe it or whether or not this was the Google link that they followed. And then, but the people who really believe it, I think, and I don't know if this happened in prosecutors' meetings across the country, I think when this really started back about 10, 15 years ago, that they realized that this is a way also for the system to collapse. That if the courts actually have to litigate this issue over and over again, so we need to shut it down right now. And so I've seen prosecutors turn excuse the phrase, hella hard over what would have been an easy, reduced to parking, pay the 113, keep moving, and now suddenly every single one of the counts on your speeding and your ticket, right? They always charge like 4 or 5 violations. That you're going to plead to every single one of them. And back when it was criminal, we're going to have suspended sentences, and you're going to have this time frame. And I'm revoking all other offers. And so that you come so hard at somebody that literally the sovereign citizen is like, why are you targeting me? It's like, well, you had your choice, you made your bed. And now they have actually motion responses, brief banks on the issue that they literally just file it to whatever they can file it the same time, every single time, and eventually judges will just get rid of it, and then you're stuck there. And by the way, you now have $5,000 worth of fines.
But it's always seemed like the ultimate technicality to me, right? You've written my name in capital letters on the caption of the complaint, so you can't charge me. It's one that we see.
Yeah.
I think the argument is very, very abstract, and it's like what rights does the government have over your body, really? Using the municipal road.
It's wonderful for political science class, as Ben had talked about before.
Abstract discussion, but
But it won't work in tax court. It's kind of parallel to the income tax is illegal, or unconstitutional. Yeah, try that. Be a sovereign citizen in the IRS court, so it won't work.
So that part of the sovereign citizen I like, no taxes. Being thought of as a nut and a crazy person, that's why it keeps me away.
It's one of those things that's why I said I think they usually start on the Wikipedia page and go, because I think there were some successes in the beginning, and then it just blew up. Well, now everybody's a sovereign citizen, and they were like, nah, we don't like any of this. And so there's been a big shutdown on it. But you'll see it pop up. You'll see, but I think the harsher the response is from either the prosecutor or the judge, if you're not well vested with that, if you're crazy, hasn't led you all the way down that rabbit hole, I think you pop out real quick and be like, oh, nobody likes this. Okay, what do I need to do? And they just fall in line.
So does anyone on our panel think that it's a good idea to represent yourself on a significant criminal case?
If you want to.
I would say no.
I understand you have the right.
Idea?
Yeah, different question.
No.
Right, I have the right to spend my paycheck on 00. Probably not in my best interest most of the time. Occasionally it might be.
Without an attorney, I think it's just a bad idea, whether you can afford one or not. So, just because of the procedural rules, and you editorially, of course, you come off to juries as like, I don't know. I just think that you just come off wrong. One thing we haven't talked about with attorneys having to step away, if you look at counselors and if there's any kind of misplaced kind of bias. So there are situations where, this person did know their case very well. They left it up to the lawyer, and the lawyer didn't do this, and this, and this. And instead of going to the jury, they did a plea deal, and they're stuck with this lesser charge, doing time. And,
But in that situation, if the attorney makes a mistake or does something egregiously bad, and trust me, the conduct has to be very bad.
Very
Falling
bad.
asleep at counsel table, showing up drunk, whatever it might be.
And that's a maybe.
Yeah. They've got remedies for that, right? And we hear about these cases because they go through the Court of Appeals or they end up in post-conviction or someplace. If you're pro per, you don't get a complaint that you didn't hire the right expert
I
or
agree.
ask the wrong question.
I think your quote was Abraham Lincoln, that person represents themselves, because if I was accused of a crime, I would not represent myself. You would want someone with that sort of dispassionate view of the case, because obviously it's personal, and it'll never be. And I've told clients is that I know this case is obviously more important to you than it is to me. It'll never be as important to me as it is to you. I get that. But you need someone who can look at things objectively and look at things and see the other side, because so many times when your clients just can't even entertain how things look. Like, some facts obviously can be interpreted in different ways, and so when you look at that and tell them, I can't even think of an example now, but okay, a jury can see this, and the prosecutors are going to say, you did because of whatever. I don't know how to.
Constantly have.
Oh, I was going to say, can I play devil's advocate on this one? I'm going to change my answer to like never should you represent yourself because of what the other panelists said, and I'm going to change the answer because I have seen some lawyers that are so bad that the client may have been better representing themselves in two veins. First, Ben, you're totally right. You need somebody who's going to objectively look at your case and evaluate it and know it and give you real advice. That's not the highest standard, but that's not the highest, right? That's not the highest standard. That's just what is diligent. That is what lawyers are supposed to do. But on a regular basis, I have seen attorneys that are appointed to clients or even been hired. It is really irrelevant nowadays. That still, even though they are paid in some form, are not paying attention to your case, not listening to the client, not doing a fact investigation. They look at the record or they deal with the client's attitude without recognizing the plain, obvious mental illness, right? That is, I mean, I would say that if your lawyer has shut you down, which is usually when I see these motions to dismiss counsel, either it's because the lawyer is not communicating, that's an ethical rule. That's because they're not visiting you, right? Ethical rule. They're not giving you the discovery, ethical rule. The things that you need to have competent representation you're not getting, that is usually where those motions come from.
But in all candor, that's not always the case.
Not always, no, but there are a number of those cases.
As an example, I often have clients that will say, you don't believe that I'm innocent. And I say, it doesn't matter. And I have to do what Ben said, which is I have to be objective. And I have to tell you how a jury's going to look at it. Whatever I believe, I have to do the same fight. But that is awful hard for somebody who's accused to take. They buck up against it. If you don't believe in me, you won't fight for me. I've got a duty to fight. But to some extent, I'm not a cheerleader either. The one thing that's always phony in the movies is that the attorney's bothered when they represent a guilty client. It does not bother me to represent a guilty client. It is part of the system. If we could only represent the innocent, there'd be a lot of people who didn't get attorneys. And I've always thought of the analogy of internal affairs.
Yeah.
With the police department, the defense attorneys often play that role, right? If I get something beat because somebody does a bad interrogation or goes about a search the wrong way, maybe they straighten it up the next time.
Yeah.
And it might prevent 100 people from having a bad search happen. So there is a give and take with things, I think.
Right. I mean, the system is designed to protect the innocent. I mean, that's why sometimes there are technicalities and the guilty do go free, and that's mainly to protect the innocent. I mean, the idea, ideally, is that and we're so misunderstood, I think, a lot of times of what we do because of TV and the movies that, we are here just to, I don't know, find some loophole to let, John Murderer out. But they've got to earn it. I mean, if the government is there, they've got to earn it. I mean, that's sort of my philosophy. That's sort of my thought going into this. Because you do get that question. Well, would you defend someone if you knew they were guilty?
Absolutely.
Of course I would. They've got to earn it. There's no obligation for anyone just to roll over. So there has to be evidence, and they have to prove it, and they have to earn it. Right. And I don't have a problem with that.
They pay for the
people don't like that. People don't like to hear that, and some people are shocked. You would. Of course I would.
The self-representation issue, you'd mentioned attorneys having a big role when they are active in the case, right? And I come back to the role of counsel, right? And the U.S. Supreme Court, there's a case called Wainwright v. Sykes that talks about the role that counsel plays, and it says that the method of defense comes to me as a defense attorney. I can decide to seek continuance, what witnesses to call. But the objective always falls on the defendant. And that, I think, is an interesting thing because I think that's lost some of the times. I think defendants think I can go in and plead them guilty without their permission. I can't do that, right? Nope. Unconstitutional. That I can force them to do certain things. There are certain things, the objective is always in the client's control. And I think sometimes attorneys don't communicate that.
No, they do not. They do not. I mean, and especially being here and being on the private side now and previously being on the public side, it is amazing the difference quality representation makes. I mean, not only in the outcome in the case, but the nature of the relationship between the individual client and attorney and the system, right? That when you see people treated with respect, their questions answered, the responding, most of the time, the relationship proceeds as it should. Confidentially, there's confidence between the two, you rely on the advice of the attorney, and then you have these other situations where the lack of the attorney or maybe lack of the mental capacity of the client, and there could be a very wide variety of things that there to be a rift. You always see the train wreck coming. I can sit in the courtroom and see the train wreck coming. I see the client in shackles and the box, just like the no-no-nos, or has anybody seen my attorney? That was the scariest thing, is when you're going in the box, and when I was a PD, I might have 8, 12, 15 people in the boxes in a regular day, trying to process those cases. And there's one guy there who's like, has anybody seen my attorney? Do you know what they look like? Like it literally, it would rile up my box. I was like, hey, I'm representing 90% of the people in here today. Could you calm down, sir? I'm trying to get, the business done. And it's just, I just seen it go south.
Well, I suppose that is a downside with having to take appointed counsel, is they tend to have to spread themselves thin to some extent, right? They might have 10 defendants in a given situation. But they've also represented hundreds of defendants. And
I don't even know. I tried to do a count. I think I'm around 10,000, 15,000 over the course of my career. It's amazing. As a PD, you go through a lot of numbers. And then when I was private in Nashville, I had the equivalent of a track. And so you go through a lot of people. You meet a lot of people. You know their stories. You know their family and everything else. So it is complicated. But I think that especially the rise of the pro pers is really given from a distrust of government in general, much less the person who's supposed to represent you is appointed by the same government that you don't trust, right? I think that it's symptomatic of some more societal.
Well, do you think it's on the rise of the internet? There's a lot more.
Everything's on the rise of the internet.
Exactly. Well, I always joke, like, this person graduated from Google Law.
Yes.
So it's like. So.
That is not a place. It's not a thing.
Right. Now they get a lot of degrees in the detention center, huh?
Oh, well,
They're jailhouse lawyers.
But my thing is like, I have had enough clients, like the client that represented himself and won at a jury trial. Like, I have respect. You don't know who you're talking to, right?
Right.
And it might be that it's all delusional, or it might be that it's real. Maybe they have had so many cases that they can now navigate effectively through the criminal justice system on their own. It could happen. So I've had that. I was shocked, but I was just like, okay, well, let's go. Then you understand these things. He's like, yeah, I understand these. It was great, Or I just tried another case on retrial where the client had seen the exact same trial before, and I hadn't. Now tell me how much you learn from a client who's had the exact same trial before. A lot, if you listen, if you take that in, So I believe in constitutional rights. I believe in everybody having the right. I don't think we've disproven that if you have yourself as a client that you're you're full, but I don't know if we've disproven that. But
I think we're winding down here, but our viewers did have some questions, and I want to make sure that we catch everything, or try to catch everything that they wrote in about. One of the questions, and I find it interesting about the right to appear pro se and represent yourself, was whether or not that right exists on appeal. Do you get to represent yourself on an appeal?
No. There is a case here in Nevada, the 1996 case that says that you don't have there's not a statutory right to represent yourself on appeal, and nor is there a First Amendment right to represent yourself on appeal. That was a Nevada Supreme Court case out of 1996, I believe.
So our high court, it's constitutional right to do it at trial, but if you want to do it on the appeal, too bad, so sad.
And that's an efficiency argument. Could you imagine? And they would have to. The courts have to do what they have to do. If it's filed, and you represent yourself on appeal, and that would be a nightmare. So that makes sense.
there were some questions about myths, what I call myths, surrounding public defenders. One of the questions was, how do they do financially?
How they get paid?
How do they get paid, or do they get paid? Or what's the old one that we used to hear, that you get paid by the guilty plea, right? I get a $200 bonus for every guilty plea.
No,
That's true. I'm in the wrong lane.
Yeah, no, but public defenders get paid salary. They're salaried attorneys, right? Lots of attorneys are salaried attorneys. The good part is they don't, it doesn't matter if they're in 18 trials or no trials, or they manage their own time and their own caseload. So there's no benefit to them working less on your case. There's no benefit to them dumping your case any faster. There's no benefit. I think that I'm really glad to know that the track work, that you actually have an incentive toward trial, because I think that helps dissolve a little bit of the myth that it's the turn and burn and the faster you can get through the cases. But the public defenders, no. I mean, that's what I told clients. I don't care what you do. It doesn't affect my money. You know, I go home every night. It doesn't, I mean, you want to try this case? Cool. Do I think you should? No, because of A, B, and C. But if you want to, let's go. I love trials.
I also tell them the one advantage of a public defender is I can tell you the truth. I don't have to try to hustle money.
Nope.
And the good attorneys don't, right? And none of the attorneys should, but I hate to say it, but I've done this too long to live in that reality.
Yeah.
Right? That people get hustled for things that the attorneys may know aren't going to come through.
Yeah. No, it happens all the time.
I dealt with that a lot too in private practice, even before I had the track. It's just, you just don't want to make promises that you can't. Because they came to me and it's like, well, I spoke to an attorney and he said that even like on a DUI, I can get this in a reckless driving. I'm like, then go with that attorney. You just came here, you got your DUI like last week. You don't even know what your BAC is.
Yeah.
And he's promising you a reckless driving. It's because he wants you to sign up and take your money.
Right.
Okay. I'll be honest.
Absolutely.
I don't know. Right here as it stands now, without reading anything, knowing nothing about your case, I can't make that promise, and I won't make that promise. And there's a reason you came. The reason you didn't sign up with him because you didn't trust him. And I said, you know, it's a sad reality that. In the competitiveness, at least in private practice, that there are attorneys that will badmouth other attorneys or make promises that they can't deliver, that I think they know they can't deliver, just to get someone signed up and later, oh, you know, your case a little more complicated than I thought, and I'm not going to be able to.
I think a lot of it, to go to your forensic accounting background, I view my role almost like an actuary.
I'm sorry?
Almost like an actuary. To some extent, I'm figuring out risk for clients and I advise them of risk. And it's almost never my job to promise a result because I don't know what's going to happen. If I'm being honest and candid, even though the best laid plans of mice and men, right? Things can go south very quickly. What?
For some unknown reason, too. For something you never calculated yet.
But to bring it back to the pro se defendants, a lot of times I see defendants that want to represent themselves that have got rose-colored glasses that are 4 times as thick as mine, right? That they say everything's sunny and the judge is going to dismiss this. And, I got a call recently from somebody related to a pro per defendant, said, do I need to be in court to pick the person up? I said, why? And they said, well, they've got a motion to dismiss on today, and they said I should be there to pick them up. It's a homicide case. I think you're okay. I don't think you have to be in court to pick the person up. Yeah.
Really.
So, reality, I hate to say it, but we have to give bad news, right? Like good doctors, sometimes we have to give bad news, and it's not always easy.
Yeah, and I know we're wrapping up, but I think a concept that we may not have directly touched on is that, now today, I don't know if it applied 200 years ago or whatever, but it's not pragmatic, it's not practical, because the lawyer today and the defendant, it's like there's 2 totally different rules and you can't mush them up, So I just think that for that reason, I don't think it's a good idea to ever defend yourself because it's just, you can't be your alter ego up there. You just can't do it,
Very hard.
Any final words, Ben?
No, I think this has been interesting. I've, I've learned a lot actually. But no, I think this is good. A lot of people don't really understand what it is we do, and so I'm glad to have this opportunity to kind of dispel some myths about
Yeah.
what it is defense attorneys do.
I guess final words are no, please don't. Generally, no, don't. If you are having problems with your attorney, though, I highly recommend that people try to get on that sooner rather than later, scheduling calls, try to make meetings, try to do that, and then go to the court if you're having a true communication, because you don't want to be the week before trial. You don't want to be in that last end run period. And, basically, and this is sort of what happens, lawyers haven't worked the whole time, you come the last few weeks before trial, and then all of a sudden there's this offer, jail, prison, felony, whatever, that you don't want, and nobody's really talked to you about you or investigated your case. That is the worst position to be. And I advise clients all the time, whether it's in private practice, retaining clients, or as a public defender, I don't live your life.
Right.
I don't have to pay your bills. I don't have to watch your children. I don't have your responsibilities. So your case, whether it's civil or criminal, manage your responsibilities. And your freedom for the criminal side is your responsibility. Your money on the civil side is your responsibility. So if you don't think it's being handled the right way, be active on it. But treat everybody with respect. Respect their time. Respect your attorney's time. Make an appointment. If you can't make an appointment, if you can't get a return call, those are issues. Send an email. Follow up. Don't say, well, I called 2 weeks ago, nobody called me back, and I've got a trial in 3 weeks, because then I only tried 5 weeks beforehand to start. That's you handle your responsibilities, you handle your business, and get a competent professional to help you with that, and that's how you're going to resolve your case the best way possible.
Your advice is so good, I think it could apply to the attorneys as well.
Yes, it does. It does.
Oh, yeah.
All right. I want to thank the guests today. Theresa, Ben, Fikisha, always great. I'm Scott Coffey, and this has been Our Nevada Judges. Thank you for tuning in.